For rebuttal, if I could, Your Honors. Let me describe what happened in this case. First, let's go with the indictment first. He's charged in an indictment of count 1, solicitation of a minor, count 2, sexual battery aggravated because of the age of the alleged victim, and count 3, sexual battery for the age of the victim as well aggravated. Those two counts, counts 2 and 3, are alleged in the indictment to have occurred between August of 2015 to August of 2017. That's relevant to what we're going to be talking about mostly, in my argument at least today. What happens is that these two counts, counts 2 and 3, regard a single incident of a hug that occurs in a shed on the property of Mr. Vasquez. The young girl's his stepdaughter, and she alleges during trial that he hugged her and touched her on her outer clothing on her breast and buttocks. That's counts 2 and 3. She testifies to that at trial, but during her testimony, and I'm going to talk about why I believe it was elicited by the state, but during her testimony, she also mentions another incident. She says that during the time in question, that Mr. Vasquez poked me in my vagina. I'll use just the poking incident from now on, Your Honors. The shed incident is what's charged in the indictment. The poking incident is uncharged, unnoticed, and had no, until that moment, the defense counsel in this case had no knowledge of it. The prosecutor, the state, asked the question open-endedly, and she says, he poked me, and then she goes back to the shed, gets testimony regarding the hug and the outer touching of breast and buttocks, and then goes back to the poking. And if you look at the transcript, I think around 251 to about 260 in the transcript, you see the testimony from on direct that goes to the poking incident around 3 times until objected to by trial counsel. I should note I was not trial counsel, I'm appellate counsel in this case. I'm relying completely on the record. But what we have then is trial counsel going to the bench and saying, that's uncharged conduct, Your Honor, that's 404B, which naturally, that's the first thing you would think of in a situation like that, I think, if you're trial counsel. Judge says, I'll have a jury out, and says, okay, what are we doing, and listens to argument. It goes back and forth between the two sides. I think, and I want to point out something at this point, that I think the state may have made a slight mistake in their brief. If you look at footnote 2, the state seems to imply in their brief today that the state at the time was unaware of the poking incident. But if you look at the transcript at 259 to 261, you'll see that the young lady testifies on her proffer that she told the church lady, she told the detectives, and she repeatedly says she told the prosecutor about the poking incident. So I think that's important because of a case I'm going to mention that we have no one cited that I've just read back over the other day, and I'm going to have to probably file a letter brief on this, but I'll talk about that in just a second. But it's also replete in some other opinions by this court. Now, the court comes back from recess and says, you know what this is? This isn't 404B. This is actually an exception under the Rickman case. Now, State v. Rickman, I know this court, you all were trial court lawyers, you know the Rickman analysis as well. Rickman is a very narrow exception to 404B allowed in cases where children cannot remember the events that occurred. They know, they can say they've been abused, they can talk about the touching, they can talk about the sexual acts, but over the course of time, they can't say, well, it occurred at Christmas. They can't narrow it down. So the prosecutor usually indicts on a separate time period. And by the way, we do have a time period in the indictment, right? We have August to August of 2015 to 2017. So we have a spread of dates, but Rickman talks about a systemic abuse by the young child where she can't identify anything particular, but when she testifies, and the state typically would elect at that point, and that's what Rickman, the narrow test. We have not gone with the broad, test in Tennessee. We've gone with a narrow test, and that's confirmed really it's confirmed as late by the Supreme Court of Tennessee in the State v. Qualls case, where it reads, therefore, where the indictment charges that sex crimes occurred over a span of time rather than on specific dates, then evidence of an unlawful sexual contact between the defendant and the victim allegedly occurring during this time charged in the indictment is admissible. Meaning, essentially, you can have an exception to the 404B analysis if you have a broad-based systemic sexual acts over a course of time. The indictment charges that over a course of time, and she or he comes in and talks about a sex act that occurs during that time. That's not. Go ahead, Ron.
No, I'm sorry, I didn't mean to interrupt.
Go ahead.
Let's assume that at least I agree with you that Rickman doesn't apply.
Yes, Ron.
Is the evidence otherwise admissible under 404B?
No, Your Honor.
Why not?
Well, first off, although the rule, I don't know why we did this when we crafted the rule in Tennessee. It is more protective in Tennessee than federal, as we know, a four-part test. But notice was not at all given. Now, this is usually cured by defense counsel filing one of either two motions, right? A 404B notice or a bill of particulars, both of which might have prevented this problem. Do we have a potential IAC? Maybe, and that's second issue also too. But a lot of times it's better to cure these problems now and to resolve this now in a mistrial. What we have is the court conducting a secondary analysis. Actually, and that goes to your question, Your Honor. He first does a Rickman analysis, and I would argue that doesn't apply, and I'll talk about that more in a minute. But a 404B analysis he also conducts. And he finds that the testimony of the young lady is clear and convincing, which I would submit that's a bit of a stretch. There's only one witness to any of this testimony, it's her, but that's his discretion. What he also finds, though, obviously, is that the unfair prejudice does not outweigh the probative value.
So what's our standard of review on the 404B question? So, and the reason I ask is because it looks like the trial court is holding the jury out hearing when it's requested. It looks like he's making a finding of a material issue other than propensity. Maybe we argue about what the actual issue is, but it looks like he's making a finding.
Yes, Your Honor.
He's making a finding that the evidence that her testimony is clear and convincing. And we can argue about that, but the court's obviously crediting her, and that he's conducting the balancing. So it looks to me like we're under an abuse of discretion standard. Do you agree with that?
I'm forced to have to agree. You know, it's one of those questions of mixed law and fact that I would like to argue that it should be a little more de novo than
Sure.
some. I think that, let me try this. I think that you may be under abuse of discretion standard, and I think I wrote that as a standard review in our brief, but I think it's apparent on its face.
So as a matter of law, the evidence is inadmissible.
Your Honor?
As a matter of law, the evidence is inadmissible?
I would say, Your Honor, no, maybe not as a matter of law. On its face it is, because consider this, Your Honors. It is our position, and Mr. Vasquez's position, that the poking incident is far more intrusive and egregious when you consider it in light of the charge conduct. Think of the charge conduct. The charge conduct is outer touching of breasts and buttocks during a hug at one single incident in a shed. The poking incident is the poking of a woman's most private place and is intrusive to a point where I think on its face, and I think that this court and our Supreme Court has said other sexual acts are the very nature of unfair prejudice when they come in. In fact, I'll go to a death penalty case I did years ago, Hubert Glenn Sexton, where I argued to the Supreme Court that the sexual acts were 404B that should not have come in, and that case was reversed on those grounds.
Sure. So, not that I want to get into ranking of sexual acts necessarily.
Right.
But I think really but I understand the argument that you're making. I think really with the standard review, it comes down to this. You and I may agree that the appropriate decision in admitting 404B evidence is on this end of the spectrum. General Hornsby, your adversary counsel, may agree that perhaps it's here. Trial court may believe that it's over here. So long as it's in the range, though, and it's not wholly unreasonable, I think this court has to defer to that under an abuse of discretion, even if I disagreed with it, so long as it's not outside of that range. And that's why I asked the question, as a matter of law in this case, that evidence wasn't admissible on the balancing. Because as soon as we concede that at least one rational person could have reached that conclusion on the balancing, I think it's game over, isn't it?
I'm not sure that's correct. I hear what you're saying, and I think that is an absolute perfect recitation of abuse of discretion standard, but in this case, the entry of unnoticed, uncharged conduct in the middle of trial, and I point this out because I think the record reflects this, although I am not alleging bad faith, that is elicited by the state as a tactic to use uncharged conduct in this manner, aware that the poking incident's there, but not allowing. Think about the fact that the trial counsel, the difficulty he had when he got to hear this, and it turns his whole trial on its head. It turns Rule 404B on its head, actually, I think, as well. But when you're saying, okay, this judge made a decision in his discretion to find that the danger of unfair prejudice did not outweigh the probative value, I'm not going to concede that, but that is probably our standard. I do believe, though, that on its face, that the unfair prejudice was not something a reasonable person could have found would not have affected this trial, would not unfair prejudice. It did not, its probative value was slight.
So that's why I'm asking. So as a matter of law, then all reasonable people would conclude that the prejudice outweighs the probative value.
That would be my argument, I guess. I'm forced to make that argument. Whether this particular judge is unreasonable or reasonable is not the question, but the question is, at that moment in time, he made an unreasonable decision to find that uncharged, unnoticed conduct that was elicited by the state, in my argument, that was far excessive. I don't think we're really arguing about scale, but I do believe that the scale of the uncharged conduct does far outweigh what was charged conduct. I had to affect the jury. Now, what cuts against me a little bit, I'll just go ahead and mention this, what cuts it, is count 2. He was acquitted of count 2. So the breast touching, he was acquitted of. But that still doesn't mean he is convicted of count 3. We're not here for the solicitation. I am not arguing about today. I'm only arguing about count 2 and 3, by the way. So
you've mentioned pretrial notice a couple of times. I think I may have missed that in the brief. Can you argue a little bit more, please, or explain? Well, what you mean?
As a natural course of events in my criminal defense practice, I file a discovery notice, a bill of particulars, typically, and a notice of 404B. Right. We don't have that. We have the state saying, actually, in the trial, in the transcript, we did not have to notice him on this. We did not have to notice him on this, implying also that she or the state knew about the poking incident. I believe that when you're going to use something as serious as this uncharged conduct in a trial, and there's no evidence that there's no direct evidence as a tactic, that should be noticed. That's part, we have to have some notice of what we're facing in a jury trial. We have to, some notice. The indictment's supposed to give us notice, and if it doesn't give us adequate notice, we're supposed to file the appropriate motions. Bill of particulars are not always granted, by the way. That's another thing in the discretion of the court. So we do have a case, I do want to point out before my time, that we have one case that kind of talks about this sort of tactic to go ahead and indict this sort of spread of years. You have one incident, and then you try to get the uncharged conduct. And I have to admit, I looked through my brief, and I think we filed a reply brief, which we did restate a lot of our issues in our reply brief, so I'm not sure there was a lot that was new there. But it's State v. Carter, and this is when Judge Wells, this case didn't get cited, and it's because it's unpublished. And I'm showing my age, but I'm not quite sure what the effect right now of it used to be the unpublished cases was not precedent, but this case comes out of this court. Judge Wells wrote the opinion. The state has not had a chance. I just looked and found it in our notes yesterday and looked at it. State v. Carter, the date is December 16, 2010. And what it sort of goes into, there was a bill of particulars in this case, but what the court sort of says, they talk about the Rickman exception, and they go, although an issue regarding the time from this incident, the scenario presented in this case is distinguishable from one stated in the purposes Rickman. A child victim alleged she had been abused, provided a vague description of events, and the state had to wait and see what the child testified to. That's not what we have here. I believe the court should follow the state to introduce evidence within the time frame. Here, the state chose to use the Rickman exception as a tactic to allow the jury to hear that the defendant had also digitally penetrated the victim, not because it needed some latitude dealing with a young victim unable to say a specific date. They find reversible error in this case, with the trial court allowing the evidence to come in of another uncharged sex act. They go on to say, thus, after a thorough review of the record, we conclude that it was not proper to apply a Rickman exception to this case, one in which there was only one indicted offense. The state provided a very detailed bill of particulars describing a Vaseline incident. Then they went on to cite that they included and admitted uncharged conduct. They reversed that case. That case does not look to have any more history after that I found. So State v. Carter, if the court would like, I could do a letter brief and make sure it gets filed to the state if you would like me to do that. I might do that anyway, and it can be taken for what it's worth. The State v. Carter case. Rickman still is the law in the state of Tennessee, but 404B is too. And a ruling on 404B can be abuse of discretion. Put yourself in that trial for a minute and think, this prosecutor knows she has this poking incident in her pocket. She elicits the testimony. The transcript is fairly clear. It's fairly apparent. She elicits on direct examination and open-ended questions that the incident touching my buttocks and breast occurred in the shed, and oh yeah, there's a poking incident. And all of a sudden, he's trying a case with another count that he didn't know, a different incident, a different time period. And what do you do except ask for a mistrial in that case? The court does conduct an out of jury. Of course, the court says, I wish this would have occurred before it went out to the jury. And one more thing, our defense counsel did not object until about the second or third time that this poking incident was mentioned. I don't think that was waiver. There's reasons to hold off and wait a minute sometimes on objections. That's a different issue. I think the state argues that at one point in their brief. But at the time, he's forced to have to pivot into something different in the middle of trial. And that's not what our trial system and our criminal justice system is about. It's about notice, it's about preparation, and it's about defense. Let me point out, let me look at my time real quick. The second issue is a little bit of a harder one for us because under 613B, I think that the court is correct. What happens in the second issue is that trial counsel has essentially a rebuttal witness on cross-examination. He doesn't ask the victim a series of questions that would elicit the ability to use extrinsic evidence. What ends up happening then is he has this rebuttal witness he wants to put on, but he hasn't asked the questions he needed to ask the witness in question to elicit a potential rebuttal witness. And I think all that's reflected in the record as true. What I would argue, and what we have argued, is there's an interest of justice. What this case is a she-said case, not even a he-said, just a she-said, only one witness. The credibility of this one witness is crucial to the jury finding a guilty verdict or a not guilty verdict. In this particular case, he wanted to recall the victim and then ask her the questions and then put his rebuttal on if he had to. And the court, in its discretion, did not allow him to recall that witness, citing, though, the main reason as she's a young witness in a sex crime, I'm not going to let you do that, okay? Competency in Tennessee, all witnesses are competent in Tennessee, unless otherwise presumed not. And we have sort of that rule of 8, I used to call it. It's sort of an older rule. You all might know it. If you're 8 or under, you might not be competent, sort of a presumption, but it doesn't really operate that way. She was competent to testify. That's not a good enough reason. So I would submit that's not a reason. I think that in the interest of justice, the court should allow him to recall the witness, put her on the stand, ask the questions, and if he got the right answers, use a rebuttal witness. If he didn't, he'd have to accept the answers.
Was the interest of justice also informed by the fact that trial counsel knew of the question to ask but simply forgot to ask it?
I don't know if that is reflected in the record. It looks like that might have been the case.
I mean, if it were the case, hypothetically speaking, that would weigh into an interest of justice analysis.
It would, and it may end up being an IAC claim later when he's being questioned by me at some point in a post-conviction hearing. But at the moment, we don't know. What we do know is he had this witness in the wings, and he thought he could put him on and say, you know, she said he was just playing around, which would bear into the sexual gratification, for example, and things like that when it comes to the crimes. But if she would have admitted that she said that to this pastor, then he wouldn't have been able to call the extrinsic evidence. But he looks to me to have, you're asking me to interpret the record a little bit, he looks to me to have made a mistake in the rules and not taken the time.
witness,
You know,
right.
had the witness and thought of you. I think, though, but you know what? That does bear into it. And I think, why would we make a defendant in this case pay the price for mistake of a lawyer? I realize that post-conviction's time perhaps to raise these issues, but why not cure it at that moment? Why not fix it then? And to say that she's too young and I'm not going to let you recall a witness is just not enough reason, I think, under the interests of justice. So if the lawyer made a mistake and it can be cured by a few questions, our position is that should have been done. So considering that, and then of course we have a sufficiency evidence analysis based on the fact that it's outer clothing and it's just this woman's testimony, this young girl's testimony, but that is what it is. I'm going back to the, I'm going back to the Rick.
You probably have no rebuttal time left. Or getting very.
I'm burning my
You
rebuttal
have
time.
no. You have
I
no
will
rebuttal time.
sit down and wait for that. Thank you.
Thank you, thank you.
Good morning, Your Honors. Abigail Hornsby for the state again. This court should affirm the defendant's convictions for aggravated sexual conviction for aggravated sexual battery. First, the court properly exercised its discretion when it admitted 404B evidence. Second, the trial court properly excluded testimony about the victim's prior inconsistent statement because the defendant failed to lay the required foundation. And finally, there's ample evidence to sustain the defendant's aggravated sexual battery conviction. So first, the 404B issue, that the standard of review for that is an abuse of discretion. And the trial court here substantially complied with 404B, and it properly exercised its discretion when it allowed the victim to testify about this uncharged conduct. So first, to just briefly address this new notice argument, the defendant hasn't raised any pretrial notice arguments in his brief, and they're waived and cannot be raised for the first time at oral argument. The trial court complied with Rule 404B. It, upon request, held the jury out hearing. So the way this evidence came in is the victim was testifying about this shed incident where the defendant hugged her inappropriately, and then she also mentioned that he had also, quote, poked her in the vagina. And my impression from the record, and I would rely on the record for this if I'm incorrect, my impression was that the prosecutor seemed surprised by it. I don't recall exactly what the testimony was at the proffer about who the victim had told, so I may be mistaken, and perhaps the prosecutor did know. I'll acknowledge, I just don't recall at this time.
If the state knew or reasonably should have known, what should the state have done?
You know, I think in an ideal scenario then, you would want to try to have a 404B hearing in advance, but
Or at least give notice?
perhaps, but again, the defendant has waived any notice requirements, and
I mean, what I hear your friend arguing, and I could be wrong about this, but what I hear your friend arguing is that the state had actual notice that this was an issue. It didn't provide the notice to the defendant, waited till trial to sandbag, and State versus Carter does not allow that to happen. That's what I understand the argument to be.
That is what his-
Admittedly, I've got State versus Carter here, and I'm reading through it, and in subsequent cases as it goes. What's your best argument to that, though?
that he did not raise that argument in his brief. I'm not prepared to talk about notice today because it has not been raised until today.
Okay.
So if
That's
the
fair.
court would like additional briefing, it is free to request that, but at this time, the defendant has not raised.
I'm not requesting additional briefing, so, okay.
Yeah, so that issue is just waived. And the court complied with 404B requirements. So again, this evidence kind of came in slowly, and then the prosecutor asked these follow-up questions about, so is this the shed incident or is this a separate incident? And at that point, when it became clear that she was talking about a separate incident with this poking, then defense counsel objected, and I think that seemed to be when everybody realized that it was a separate issue. And trial counsel even said that it seemed, because defense counsel was getting, understandably very worked up about this, and the trial court was kind of just, all right, everybody calm down. It seems like everybody was a little bit confused about what her testimony was. just because it was unclear. And the court was not required to hold the hearing before the defendant requested it, so it appropriately held the hearing when it was required to. It explicitly found that this testimony about the poking incident was material to intent because of the unique circumstances of the defense in this case. So we haven't talked at all yet about the text messages that the defendant sent. He had sent the victim several text messages trying to convince her to come to his room, saying he wanted to, quote, lick her beautiful tits, and trying to solicit sex, and essentially telling her that it was okay for stepdaughters and stepfathers to be together. And his claim at trial was that this was a test. They were concerned that the victim was interested in older men, including him, and he wanted to prove to his wife that the victim was not interested in him. And so the court found that this additional incident and additional testimony under this very unique defense was relevant to intent, because if the defendant, and was relevant to the jury's ability to determine whether or not that actually was a test, and whether he was, actually trying to test her or trying to solicit sex in that instance. And the court was correct in concluding that it was highly relevant. It was the same victim in the same time frame, and again, very relevant. The court also made a credibility determination, found that the victim's testimony was credible, and that the proof was clear and convincing. And it also found that, again, because of the very unique circumstances of this case and of the defense in this case, that the probative value outweighed the danger of unfair prejudice. And it was relevant to the jury's determination of what the defendant's intent was when he sent those text messages. And I don't think, in this case, I think it's important to acknowledge that, generally speaking, in a lot of sex offenses, this evidence wouldn't have been admissible under 404B. Generally that stuff is much more prejudicial. But with the defendant's the defense and the arguments that he was raising in this case, it fell into 404B, and the trial court did not abuse its discretion by admitting it. Turning then to the victim's prior inconsistent statement, as the defendant acknowledged, he failed to lay the proper foundation here, and Rule 613 mandates its exclusion. 613B does allow the court to depart from kind of those foundational requirements, but that flexibility is only available in extraordinary circumstances, is I believe the language in the rule.
So General, as I was talking to your friend, I had thought I had taken from the record, and maybe the briefs, that the defense counsel knew of the inconsistent statement that the victim would have testified to at the time. Otherwise, maybe it's just an inference. Otherwise, why would you call the pastor to testify, right, if you didn't already know that there was an inconsistent statement there? In your review of the record, did defense counsel know of what the victim would have testified at the time that the victim was under cross-examination?
Yes, and the trial court found that explicitly.
Okay.
And if I may be mistaken, but I do seem to recall defense counsel acknowledging that he knew
so
about it.
there's a trial court finding, though.
Yes, so there's a trial court finding. The trial court focused on kind of a couple things. I think the primary thing is what you just said, that defense counsel knew about this and simply failed to ask the question.
And that's a factor that would weigh into the interest of justice
Absolutely,
analysis. Okay.
absolutely. And then in terms of recalling the witness, this isn't a situation where the witness testifies and then something else comes up during trial and defense counsel wants to recall the victim. I think that would be, a different scenario. But combined with the fact that defense counsel knew about it before the trial began, planned to call this witness from the beginning, just failed to lay the foundation. And then it is a young victim of a sex crime, and this court and the Tennessee Supreme Court has discussed extensive policy that like as just policy reasons for trying to protect these victims from having to testify repeatedly, unnecessarily, and just protect them from the trauma of testifying. So the court was also concerned by that, but I think more important was the fact that the defendant also knew about this, because certainly there are instances where you can recall a child victim, but there has to be a good reason for that, and simply forgetting to lay the foundation, or perhaps he chose not to lay the foundation. It's unclear from the record why that didn't happen. But it wasn't.
The substance of the statement, I interrupted again, and my apologies. The substance of the statement I'm curious about, maybe just from your perspective. The substance of the statement was the pastor would testify that the victim told him that no crime had been committed.
Yes, so it was something along those lines, and I think that's kind of the third prong that I would argue, is that this statement wasn't really all that helpful anyway. So to the extent there was any error, it absolutely would have been harmless, because I believe the statement was either that he hadn't done anything wrong or hadn't done anything illegal, is
right,
what
okay, all right.
I believe she used the word illegal. It was either wrong or illegal, but that's not really a helpful statement, because whether she thinks that what he did constitutes a crime or was illegal really has no bearing on her credibility, or she's not a trained lawyer. She
Or what
presumably
the law
hasn't looked
or
at
what the law prohibits, right?
Right, yeah. And she, presumably doesn't know the elements of aggravated sexual battery. So there's not really anything helpful to the defense in that statement. And so the court properly exercised its discretion here when it excluded that statement and excluded the pastor's testimony and concluded that the defense should not be allowed to recall the victim. And finally, to just briefly address sufficiency of the evidence, the defendant's primary argument here appears to be that it did not rise to the level of physical contact, but simply because it was over the clothes. But the statute explicitly defines physical contact or sexual contact as the intentional touching of the clothing covering the immediate area of the victim's intimate parts, which includes the buttocks. So statutorily, it certainly did rise to the level of sexual contact here. And the only reasonable conclusion for the jury to draw in this instance with these text messages and the defendant's inappropriate grabbing of the victim during this hug is that it was for the purpose of sexual gratification. And if this court has no further questions, we ask that you affirm the conviction. Thank you.
Real quick, Your Honors. Page 260,
Is that a promise?
Very much of our promise. Page 260, page 261 is the when she's on her proffer describing who she is told prior to trial. Our argument would be that notice should be inherent in a Rule 404B. Uncharged conduct should be something the state should always endeavor to disclose ahead of time to prevent this kind of thing. If they're going to link the solicitation, which I'm not arguing, to the intent element, I would submit that I was looking for my indictment. Solicitation counts occurred in 2019. These are counts that occurred in 2015, 2017. The touching, the sexual batteries occurred in 15 to 17. Solicitation occurred later. And she also says, not just that I don't think he did anything illegal, but I thought he was playing around, just playing around. I think that does have bearing on intent, and it would have been useful if she had said something otherwise. Thank you, Your Honors. I would hope this be remanded for a new trial. Thank you, Your Honor.
Thank you.
All right, thank you. Let's take about a 5-minute recess.
All rise. This court will be in recess.
I didn't mean to say that.